Good morning, Ms. Lenyai.
Good morning.
Are you ready?
I am ready, thank you.
All right. How are you?
I'm well, thank you, and how are you?
I'm fine, thanks. I see that you were born in my hometown.
Yes, that's where my mom comes from.
Oh, you still have family there?
Yes, I do.
All right. Well, not such a great place these days. Not what it was when I was a little girl, at least. Yeah. All right. You hold a BProc and LLB degrees,
Yes, DCJ.
and you're an attorney by profession.
Yes, I'm an attorney.
You're a conveyancer and notary public as well, I see.
Yes.
Okay. You have practiced with various firms of attorneys through the years, including for your own account, right?
Yes, DCJ.
And you currently run your own practice
Yes, that is correct.
since 2018.
Since 2018, yes.
How is business?
Well, the business is doing well under the circumstances. After COVID, there were a bit of challenges, but fortunately enough, this year, the work has been very well. Thank you.
And now that things are going well, you want to go to the bench?
I don't know how God works.
Yeah. I see that you are a member of a number of legal organizations, including the BRICS Legal Forum.
Yes, I am. That is occasioned by the fact that I serve as one of the leaders of the Law Society of South Africa. And in that capacity, you get seconded to all these other international bodies to represent and fly the flag of South Africa.
I see. And you are also a member of community organizations as well.
Yes, I've been raised that way.
Yeah. What is this CareNet Development and Support Organization? I've not heard of it.
Which one?
CareNet Development and Support Organization.
Oh, a CareNet, or the CareNet. CareNet is we predominantly do social work services that we offer to families in crisis, children who are placed in alternate accommodations by virtue of being subjected to abuse at home. We offer a care and financial support and social services work. We also offer educational support to children between the ages of 0 to 18, as well as early child care development from 0 to 5.
All right. Well, that's a service which all our communities sorely need.
Yes.
You have indicated that you have a disability. Does it affect your performance of your work in any way?
No. This happened while I was still very young, and I have learned to turn my head in such a way that I can catch all the airwaves and I can hear quite properly.
Yeah, I can see that you're not struggling at all. Okay. You disclosed that there was once an attempt by the LPC to strike you off the roll.
Yes, I did, DCJ.
And you were suspended from practicing for your own account for a long period of time.
I was never suspended. I was interdicted.
Sorry, you were interdicted from,
yes.
from practicing for your own account,
yes.
under your own name and style for 8 years.
For very long 8 years, DCJ.
All right. What is the situation now?
The matter was resolved on the 25th of October, 2017. Would you like me to clarify further?
Yes, please.
We were, initially when the matter started, there were allegations that there were trust deficits in our trust account. These trust deficits were occasioned by the fact that the LPC sent, not the LPC, I must correct myself, the Law Society of the Northern Provinces, sent an account, their auditor to come and check our books. When he came, he checked our books and he found that, according to him, there were trust deficits. When I explained to him that there were no trust deficits because certain funds that belonged to trust creditors, we had actually opened trust investment accounts for those trust creditors. Those monies were occasioned by transfers that we did on behalf of the then Department of Land Affairs, where we were transferring property from farmers to the beneficiaries of the land claim. The farmers did not want to leave the property immediately after the transfer had taken place. In the deed of sale, a certain clause was included there to say that the farmers will be afforded a further 12 months to stay on the property, and 3% of the purchase price will be retained in the trust account of the conveyancer, which in that case was our firm. What we then did, we took that 3% and invested it in an interest-bearing trust account linked to our trust account. Immediately thereafter, the lawyer of one of the farmers started demanding the money. Now, the clause that I referred to had a further provision that after 12 months, when you leave, you need to give written confirmation to the Department of Land Affairs as well as to us, confirming that you have left the property before the funds can be released to you. When we responded to the lawyer that, has your client vacated the property? The lawyer did not respond to us. Instead, he took an application to liquidate our firm. He served the Law Society of the Northern Provinces, SARS, and the Deeds Office. So when he did that, we entered a notice of intention to oppose, filed our answering affidavit, and gave evidence that the money was indeed in the interest-bearing account. On the day before we went to court, the attorney then withdrew the matter, seeing that he had no hope of succeeding. That was the basis why the Law Society then sent their auditor, because they were in possession of that application to liquidate our firm. The judge who had the application to suspend and strike us, when he saw our answering affidavit, again, the same information was given. He did not find a good enough reason to suspend us, but rather decided to interdict us to give the Law Society an opportunity to come and verify this information.
And it took 8 years to do
It
that.
took 8 years. For some reason, they were not hearing us. I don't know why they chose not to believe us when we told them that the money was in the trust account and believed other people. After 8 years, only then was a council meeting taken to say that it was not appropriate to continue to want to persecute us in this unfair manner, despite clear evidence being shown to them that the money was in the account. When that resolution was presented to us, me and my then partner were not satisfied, because the interdict remained, and Part B also remained. And this was a very long and very difficult time of our lives. We were considered as the piranhas of this legal profession. People did not want to be associated with us. Clients did not want to be associated with us. And we felt that we needed to clear our names once and for all, so that we can start again and continue with whatever that was left with our lives. And that was what has happened. And I saw in the comments by the LSSA and the GCB, in my application, they alluded to the fact that I had not made it very clear what caused the interdict and the eventual upliftment of the interdict and the dismissal of the matter. That's what prompted me to then write a written submission that I would like to believe that all the commissioners here have had sight of. And I've just basically repeated what is in that document. Thank you, DCJ.
So the long and short of it is that the interdict no longer exists, it's since been uplifted.
The interdict no longer applies, and I believe that there are no issues with regard to my integrity.
Okay. You have acted as a judge in the Gauteng division of the High Court for a few times,
Yes, DCJ.
and you've written judgments, I hope, during those acting stints.
Yes, DCJ, I have.
How many?
According to my count, there is 47 judgments that I have written.
All right.
Some of them were written by seniors that I was sitting with in full bench and full court appeals.
No, I mean those that you yourself have penned.
The ones that I myself wrote are 40.
Okay.
Yes.
Any of them reported by any chance?
No, there hasn't been one that has been reported, although there is one that is in the pack that I had hoped that it would be reported, but it hasn't been reported. But I have been advised by some of the senior judges that they have seen my judges on Safely and on LexisNexis.
All right. Did you mark it reportable?
I did, DCJ.
Okay. All right. I'm going to stop now and hand you over to the judge president of the division you want to join, JP Mlambo.
Thank you very much, DCJ. Good morning, Ms. Lenyai.
Good morning, JP.
If I knew your clan name, I would address you that way. You've acted for a total of 30 weeks. That
Ye-
includes this latest stint this
Yes,
year. Am I
yes,
correct?
JP, you are correct.
Thank you. And those 30 weeks, do you form the view that they've adequately prepared you to take on the load of a judge in the division permanently?
Yes, JP, I believe. Those 30 weeks have adequately prepared me.
Yeah. The reason I ask the question is you've not been able, you have a very busy practice and responsibility to associations and organizations, but you've not been able to give me a full term to say I want to act for a full term. Have you?
No, JP, I have not been able to because of the other things that I'm busy with.
Yes.
Yes, like this year, you wanted to give me a full term, but I could only give you 6 weeks.
Yes.
Yes.
But am I correct that in those weeks that you've acted, you've heard the groans and screams and shouts of desperation of permanent judges who are carrying the full load?
Yes. Actually, let me just correct one thing, JP. In the first term of last year, I believe I did give you a full term.
You did a full term?
Yes, I did a full term, 10 weeks.
My mistake, 10 weeks,
Yes,
yes,
10
I see
weeks,
it now,
yes.
thank you.
And yes, all my senior judges, every time when they see us in the corridors at tea or when we visit each other in the offices, I have been asked, when are you applying?
Yes.
The workload is too much, and some of us, we want to retire, but we can't because there are no people coming in.
I think, in all fairness, I'll disclose this to you. Those comments also came to me, especially after that special motion that I gave you. You remember, you wanted to complain. Why am I giving it to you?
Yes, JP, I was under the impression that you didn't like me, but it was a very, very big judgment. It nearly broke my head. But the other reason why I wanted to complain, JP, was that I only became aware of that special motion 2 days before the matter was to be heard. However, the DJP came to my rescue. He advised me how best to prepare to make sure that I am able to get in court and listen to the parties. The matter was huge. It has constitutional aspect, administrative law, contractual law. It had everything in it. And me being a puny judge, as I've heard people referring to us as puny judge, I thought it was beyond me. But DJP advised me that that matter was given to me because the leaders of the court believe that I am capable of addressing that matter and make sure that I produce a good judgment. And I did my best.
Yes. Just to finish that part, after you heard the matter, you came to me and to thank me for giving you the matter. Am I correct?
Yes, that was so, JP.
And it's one of your, when you list the judgments you've written, it's one piece that you really treasure the most. Am I correct?
I do, JP, because that piece of work actually took me out of my comfort zone. I had to dig deep in me and also do a lot of research, and it really made me want to do more of such kinds of work.
Yeah.
Challenging as it was, I'm thankful.
Yeah. Just before I go to the other comments, I just want to thank you for availing yourself whenever I was asking you to come, because it was a struggle for you to leave what you were doing and to come, but you did come now and then.
Yes, JP.
And I want to thank you for availing yourself, because it shows you feel you're ready. Now, the comments that I've seen, I've told you the positive comments from judges. The comments that I've seen from the law bodies in terms of your current application, they are actually commendable in terms of how you've performed. In fact, what the GCB says is that your appointment will send out a good message that the judiciary puts value in people who produce judgments, well-reasoned judgments, timelessly. Did you see that comment?
I saw it, JP, and I was, I must say, humbled by it, because I am still learning. I'm still learning how to grapple with the legal issues and make sure that I deliver my judgments in a reasonable time. And to get those comments, especially from the law bodies like that, it was very humbling for me. Although I must say that there is still room for improvement. And if given an opportunity, I think I will do better than what I have been doing now.
Yeah.
Because I will not be burdened with all these many things where I am in leadership, where I have to juggle my time before I can focus on my judgments. Because this, I consider being a judge as a service to the people of South Africa. There is nothing glamorous about this work. It's back-breaking, and you really have to be committed and show resilience and be willing to put in the hard work and be willing to learn and be advised by your seniors.
Yeah.
Thank you.
Well, you left one thing in describing the work. It's also an underpaying job. Thank you very much, DCJ.
MEC?
I think I'm covered, so let me spare you time. Thank you very much.
Thank you, MEC. Questions, commissioners? Yes, Prof?
Good morning.
Good morning, Prof.
Thank you very much. I just want to speak to you about a judgment that you wrote, which I really enjoyed reading. It is on page 86 of your bundle.
Page 26.
85 actually, 85, 185 at the bottom. It was an eviction matter.
Yes.
Where you were dealing with an elderly person who was being evicted, and I think she also had children. And I mean, I fully endorse your approach and your reasoning. I think it's a very good judgment. I just want to ask you out of it, quite generally. the eviction laws in South Africa, when you look at them, on the one hand, you have the issue of arbitrary evictions. On the other hand, you have the issue of illegal occupation. And in most instances, you find that the people who are occupying the property, apart from indigency, they may be interfering with the right of the owner of the property. But our constitutional dispensation, we cannot just evict people while they are going to be rendered homelessness. I'm always curious as to when and how are we going to be able to balance the rights of the two people. When somebody who's quite wealthy comes and they have all the ownership entitlements over the property, but there is these poor people who are destitute and they have nowhere to go. And there is this issue of saying you need to provide alternative accommodation. And court after court has said this is not a duty that only resides on the municipality. And there must be a report. You deal quite well with that in the judgment. How do we balance these two issues?
Thank you, Commissioner, for that question. My personal view is that what I have observed from litigation and what is happening, the municipalities are not playing their part. There are no reports that are placed before courts to assist the courts to come to a conclusion that when you evict people, they will have somewhere to call home. The Constitutional Court calls it just and equitable. If the applicants, through their legal representatives, will ensure that the municipalities bring their reports, because the municipalities, if you do not push them, they will sit back. And you cannot come to court and ask a sitting judge, be it a full-time judge or an acting judge, to offend the presence of the Bill of Rights. That cannot be. However, me, in my personal capacity, when I have a client who has a bit of money and he is sitting with a situation where somebody is sitting in their property and refusing to move out, I do advise them that, take it as a sense of your social responsibility. Buy them an RDP house or something. Let them go stay there. Once you have bought them the RDP house, I think they can try and find ways to find out how they can pay for other services, or the municipality. There are programs there. It's called the Poorest of the Poor. They can go there and apply, and the municipality will offer them the necessary services. That is how I normally advise my rich clients. Thank you.
It is in line with the recent judgment from the CC, and I think it's the right approach. Thank you very much, DCG.
Thank you, Commissioner. Commissioner Shabangu Mdawe.
Thank you, DCJ. Good morning, Ms. Lenyai. I almost said good morning, Ms. Mabaeng.
Thank you, Commissioner. I must disclose that she is my president in Saula.
I was also going there, DCJ, to disclose first, but thanks, Ms. Mabaeng. Ms. Mabaeng, I just want to commend you with whatever you've achieved thus far. It gives courage to young women who are coming after us and you. I want to find out from you, what is it exactly that we as leaders can do to have people that can, when JPs want acting judges, they can get good people who will produce quality work. In answering that, can you also indicate if training is enough without experience or without practical? And if really practical or training, experience is needed, what is it that we can do so that we can align the training together with the practical? Thank you.
Thank you, Commissioner, for that question. I will start with the first one on of how can the JPs find candidates to come and act. What I believe should happen is that if you are fortunate enough to find yourself to be in a position of influence, you need to use that influence to bring others up. It is a slogan in Saula to say that as you rise, bring others up. And that is exactly what happened in Saula. There was a call from the JP to the Secretary General of Saula to produce a list of female candidates that JP can draw from to come and act. And the names were written there, and I remember I did not forward my name because I do not normally litigate in the normal way that people normally litigate. And I remember the Secretary General calling me at midnight, scolding me for not having presented my CV. And I did that, and I am thankful that JP, when he was selecting, he selected my name, despite the fact that I originally did not see myself in that space, because I believed that if you are not normally in the courts, you will not be competent enough to sit on that bench. And as I say, if people of influence do not use their influence to draw people out, like Saula did, like JP did, then those people will remain hidden. Us as the law bodies, what we used to do before the Legal Practice Council, the Legal Practice Act took over and the law societies, the provincial law societies were disbanded in 2018, the Law Society of the Northern Provinces, together with the LSSA, used to have what we call judicial skills training. In that judicial skills training, the law bodies were trying to upskill their own legal practitioners to make them ready for when JP calls them. I went there not because I thought I was to be called. I went there because after that hiatus of 8 years, I needed to build my own law firm, and I knew that I did not have somebody else who was going to lead the litigation department. So I went there to upskill myself. And in there, sitting judges were training the attorneys and some advocates who would avail themselves. That has unfortunately fallen off, and I put this clearly at the seat of my leaders in the judiciary, because the LSSA, we did try to continue with this in our quest for furthering and protecting the interests of our members. And the answer we got from the judiciary was that they are busy at Sajay. Now, the problem at Sajay is that if you are not a sitting acting judge, you will not be called to go to Sajay. But I have seen recently that some inroads have been made by the Office of the Chief Justice to transform that. But I think we need to also continue and go back to what we were doing up until 2018 to augment and add on what the Office of the Chief Justice is doing. In that way, we will have a large pool of attorneys and advocates that are ready and able to take on the job. Thank you.
Thank you, Ms. Lenyai. Thank you, Decision.
Thank you, Commissioner. Commissioner Matolo Tlepo.
Thank you, DCJ. Good morning, Ms. Lenyai.
Good morning, Medlepu.
Yeah, my issue, DCJ, is to declare that I know Ms. Lenyai very well, and we've been serving in structures of the BLA together, so I don't want her to be, so I know her very well. But what I wanted to clarify on the issue of your interdict, so that people don't go out thinking that there was something wrong. I was in the structures then. of the Law Society of Northern Provinces. You were only interdicted not to practice on your own account, but not as an attorney. You could
That
still-
is true, yes.
Okay. I just wanted you to clarify.
Thank you.
No more questions from the floor. Any questions from the virtual platform? Commissioner Singh, Bernard?
No, thank you, DCJ. Thank you. Very impressed. Thanks.
AP Betze, thank you.
Thank you, DCJ. Good day, Ms. Lenyai.
Good day, Acting President.
I've got two simple questions for you. The first one, you are sitting as a member of an appellate court in an appeal against sentence by an accused person. And my question to you is, under what circumstances would interference with the sentence imposed by the trial court be warranted? Generally, without regard to the provisions of the minimum sentences legislation.
Thank you. Ordinarily, an appeal court does not easily interfere with the decision of the court of core, especially with regards to sentencing, unless if it finds that the sentence that has been given is so gross and disproportionate with the presence of the law.
Then thank you. My second question to you, you are presiding in a civil trial concerning a delictual claim, and the only element which is in issue is negligence. And for purposes of establishing liability, what test would you need to apply to determine whether negligence has been established?
Thank you for the question.
In essence, the court would ask itself three questions. Could you briefly?
The court would apply what I would call the reasonable man's test. You would look into the actions of the defendant to see if the manner in which the defendant conducted themselves was reasonable. A reasonable person in the position of the defendant would have acted in that manner. If the answer is that the defendant did not act in a reasonable manner, then I would find that the test for negligence has been passed.
Thank you. Thank you, DCJ.
Thank you, AP Betze. And we have no more questions for you, Ms. Lenyai. So this is the end of your
Sorry,
interview.
DCJ. Sorry,
You're
DCJ.
sitting right next to me. How did I miss you? Okay. From the virtual platform, and the definitive answer was no. But I'm not going to stop you, Commissioner Bernard. Go ahead. Then it's you, TM.
Thank you. I'm so sorry, DCJ. This time around, I was doing the load shedding switch. Our power just went off. It took a second to just do the switch. Ms. Lenyai, morning. First, I must declare, I think it's important that I serve with you on the Executive Committee of the Law Society. But my question is also mainly about the Law Society. So just quickly, last year you were the first president of the Law Society whose vice presidents were also all women. So it was a full, let's call it a full bench of women leaders. How did you experience that, and how was that and your term as president positively impacted on female legal practitioners?
Thank you, Deputy Minister. I must disclose that I am no longer the president of the Law Society of South Africa. My term ended at the end of March, and my constituency has asked me to stay on until they can find somebody to come and step in my shoes. I'm now currently the deputy president. I found my stint as as the president of the Law Society, I enjoyed myself. I was exposed to tables that I would not normally have been exposed to. I represented the LSSA and the country both regionally, continentally, and internationally. My peers accepted me and respected me and also mentored me. It was very interesting. You are a leader of people, but they are also mentoring you. Some of my mentors are sitting at this table. I will not mention them by name. And what it has made, it has given that young girl that I see in the malls. I get stopped these days by little girls. They want to have hair like mine. They want to become attorney like me. And some of them are already referring to me as judge. And I told them, I am not yet a judge, I'm an aspirant judge. It has given young girls and young women the hope that they too, despite whatever adversaries they come through, they too can make it. It does not matter what circumstances you find yourselves in. If you think that you are not guilty of anything, your integrity is intact, it frees you up to do the work that enhances other people and lift them up. But there was also the added burden that as the first president of the Law Society, to fail was not an option. That is why I could not give my JP the many weeks that he wanted from me, because I had a responsibility to my sisters to succeed and make sure that I plant a seed in them, that it does not matter where you come from, what has been thrown your way, you just step up and do the work that needs to be done. I tell them that you need to see yourself as a brand. When you are a brand and you want people to follow and do what you do, you try to do what is best, set a good example, both in your personal life and in the spaces where you are working. You need to be exemplary in everything that you do. And I think I have managed that, because everywhere where we go, when we do outreach programs at the LSSA, BLA, and all the other structures that I serve in, people recognize that and they want to emulate that. And my co-presidents in the LSSA are also the same. And I think this is the only thing that we can do, because there is misconceptions out there about black legal practitioners that seems to suggest that we are less than. It is not that we are less than, it is only because we are not given opportunities. And I would also like to take this space, as I see the minister is there, that when it comes to briefing patterns, I must confess that I really don't think anything is being done. There's lack of political will. In my personal space, I have been put in so many panels, but I am yet to receive an instruction. People with less qualification than me get the work, and I'm here to tell you, Minister, that work lands on my desk because they can't do it. I do the work, give it to them, they bill you, and they pay me. And what I have realized is that professional black people, not only in the legal sphere, are not given the necessary space to grow. I will stop there.
Finished, Commissioner Bernard?
Thanks. Mine wasn't actually a question to, sorry, first of all, are we still mourning? No, we're not. But good afternoon. and Ms. Lenyai. It wasn't actually a question to you, but I just thought I should still ask it while you were here. Now, sorry, I've lost things in the file. The GCB, in their submission, complain that they don't have the Annexure MMD, which is the court order that Ms. Lenyai refers to. This is now when the interdict is uplifted, but it is in the file. It's on pages 113 and 114.
Yes, it is.
Yeah,
They must have missed it.
It was more to the commission. Did everybody else not get a full copy of this bundle, and why did the GCB not get it? Okay, but I just thought I should publicly raise that question. Maybe the GCB can respond later. And then maybe just quickly while I'm on the floor, yes, it's your interview, not mine, but the Department of Justice does set targets for briefing of black practitioners and specifically women. I think there is concern about reducing possibly the targets of briefings for women because of the unavailability of counsel. But that's something we can more engage on outside. But there are attempts. I'm sure more can be done. Thanks.
I don't know if you want to respond to what the Deputy Minister has
No,
just
I
said.
think I will leave it there. It is a debate
her.
for another forum.
Oh, you had put a question to him. I see. All right. Well, no further questions, it seems. I already thanked you for making the time to avail yourself of this vacancy and subjecting yourself to this torture. But it was a good interview, I think.
Thank you very much, Commissioners, and have a good day going forward.
You too. Thanks.